joining us from various parts of Asia Pacific region, from Maldives to Marshall Islands. Over the last few weeks, we have been collaborating with a number of law societies and bar associations in the region, including Fiji. This webinar aims to provide you with an introduction to the International Criminal Court and shed light on the process of becoming a listed counsel before the ICCBA. Additionally, we will explore the valuable work conducted by the ICCBA in promoting legal practitioners from underrepresented state parties to the Rome Statute in the Asia-Pacific region, as well as those from non-member states in the region. Also today, we will talk about the rule of law and the role of the legal practitioners in the region. And this is the first webinar of a series of webinars we aim to conduct as an initiative by the ICCBA to get on board legal practitioners from the Asia-Pacific region. I should thank the president of the ICCBA, Ms. Marie-Hélène Proulx, for her passion and dedication to achieve this goal. Before we proceed with our scheduled program, I would like to address some housekeeping matters and provide you with information about the question and answer session. Firstly, I would like to remind all participants to keep their microphones muted through the webinar to minimize background noise. And also, if you wish, you can keep your videos switched off, so only the speakers will be shown on the screen. And if you have any questions during the session, please type them into the Zoom chat or YouTube chat, depending on the platform that you're using. And we will have a dedicated question and answer session towards the end of the webinar to address as many of your questions as possible. However, please note that due to time constraints, we might not be able to answer all questions, but we will do our best to cover the most relevant ones. I would like to remind all participants that this webinar is being recorded, and the recording will be made available for future reference on our website or YouTube. Today, each presenter will talk approximately for 20 minutes, and therefore we will have the short question and answer session. And we are honored today to have three very distinguished speakers with us today who will share useful information about the ICC, ICCBA, as well as the rule of law in the region. And our first speaker today is Ms. Marie-Hélène Proulx. She is currently the president of the ICCBA and also associate counsel in the defense team of which Mr. Patrice Edouard Ngaisona at the ICC. She has worked on several defense teams, including as legal consultant for the appeal proceedings in the case of Dominic Ongwen, as associate counsel for Al-Hassan Abdul Aziz, and in the defense team of Hassan Habib Merhi before the Special Tribunal for Lebanon. She acted as counsel for Jean de Dieu Kahamunda and is currently a pro bono counsel for Mr. Simeone Nchaimihon. Before the IRMCT, she also worked as legal officer at the International Criminal Tribunal for the former Yugoslavia at the ICC, a teaching assistant at the University of Geneva, and a legal advisor at the ICRC Advisory Service on International Humanitarian Law at the Geneva headquarters. She will speak today on introduction to the ICCBA and ICC, including admission to the list of counsel and list of assistants. Without further ado, I invite Ms. Marie-Hélène Proulx to take the virtual podium.
Thank you so much, Rangajiva, for this very kind introduction. I am going to share my screen with you now. If it can work, just give me a minute. First of all, let me tell you how delighted I am by the level of interest that we've had for the seminar. It's absolutely fantastic to see so many people from the Pacific Islands here joining us today. I'm struggling to get to the place where I'm doing this, but excuse me, I am not very good at this, even though I practiced ahead of time. let me try again. Apologies, everyone. It's an honor for me to be here today. Voila, there we go. I am here as the ICCBA president, first and foremost, but also as a lawyer who has worked all of her life in the international arena and who has learned so much from experiencing the diverse environment that we are in here in The Hague and in the international institutions. And I think this diversity, these different cultures working together is really what makes this field so special. And that's why I'm so excited to speak to you today. Special thanks to Rangajiva for organizing this event today and putting in touch the ICCBA with so many law societies from the Pacific Islands. I think that this is a very promising beginning of a relationship, and hopefully it can lead to more exchanges going forward. So today I will give you a brief introduction on the ICCBA, the ICC Bar Association, the organization that I preside, and then I will move on more generally to the ICC and to the list of counsel. So I'm trying to, voilà. So, excuse me. So who are we? Who is the ICCBA? Well, it's an organization of lawyers that was established in 2016 after there was a realization that lawyers practicing in front of the ICC had the need for an organization to advocate on their behalf with court organs and other institutions. We are providing professional trainings related to the work of the ICC and its practice. We also provide confidential ethics advice and opinions to our members when requested. And of course, as this webinar shows, we try to establish relationships with national bars and different associations, universities, to try and foster this international legal community to the best of our ability. The ICCBA is quite a big organization in the sense that it has a lot of different committees. It is led by the Executive Council, which I preside. The Executive Council comprises currently of 15 members, but it will soon be reduced to 9. And it includes, of course, the president, a vice president for victims, a vice president for defense, a vice president for support staff, and a secretary, which is Michael Hers, who's here today, and a treasurer. We are assisted in every step of the way by our executive director, Dominic Kennedy, who's been here since the inception of the organization and without whom we could simply not operate. The Executive Council has the power to establish working groups, and we have done so recently when we've just last month created a working group on the crime of on ecocide to see whether the ICCBA should or not take a position on this crime and its admission before the ICC. We have different other working groups, excuse me, for example, on ethics, on harassment, to study a possible amendment to the code of conduct of professional practice here before the ICC, etc. But we can basically create working groups as needed and assign members to do some work on specific issues for us. And then, of course, we have the focal points, which Rangajiva is the best example of. We have 5 regional focal points for each of the regions of the Assembly of States parties. And then we have some thematic focal points as well, one on gender and diversity, and the other one on gender-based crimes. Then we have several committees within the ICCBA, one representing defense interests, defense committee. We have a victims committee. We have a counsel support staff committee. This one is dedicated and composed of a younger lawyer, the ones who are assisting counsel in the proceedings before the ICC. And of course, the Professional Standards Committee, which is the one I mentioned earlier when I said that we're providing confidential advice on professional issues of ethics, for example. We have a Legal Advisory Committee, a Training Committee, which is quite active in providing legal trainings, one of which is actually happening this Saturday. So if you want to join to this one, please ask, and we'll give you all the information to sign up. And finally, the amicus committee and the membership committee. So it's quite a big structure. There's quite a lot of elected positions. The elections take place yearly at the General Assembly. The next General Assembly is 20 October, whereby all of the positions will have to be refilled. Starting this next election, the presidency position will have a mandate of 2 years rather than one as it used to be. All of the other positions have a mandate of 1 year. We have 3 types of memberships for the organization. There's a full membership, which is reserved for lawyers who are admitted on the list of counsel of the ICC. And of course, I will come back to the admission on the list of counsel a little bit later. Then we have associate membership. This one is reserved for people who are admitted on the list of assistant to counsel and people who are working in legal teams at the ICC. And finally, we have a more general category of members, the affiliate members, which basically can include anyone who has an interest in international criminal law and who wants to be part of our legal community, of course. Our members come from over 70 countries around the world, so we're covering quite a bit of territory, and that's what makes this membership, this organization, so special. Our lawyers have either experience before the ICC or other international tribunals, or simply are domestic lawyers with criminal law experience domestically. We also have a number of academics, students, and young professionals. At this moment, our membership is about 350 members, but it has been growing steadily in the last few months. And we certainly hope that after this event, some more people will be tempted to join us. Now, one thing that we do at the ICCBA is affiliation agreements. We are trying to establish relationships with different bar associations, universities, and other organizations. What does that allow us to do? Well, it establishes a privileged mutual relationship whereby we can organize joint events and trainings. Our trainings can count as continuing legal education for domestic bars, for example, sharing knowledge and common interest around the work of the ICC, and promoting, of course, the highest professional standards and ethics. We have quite a few affiliation agreements signed already, but we're always looking for opportunities to widen our network. And I would very much like and hope that in the future we can create affiliation agreements with Pacific Islands Bar Associations, as this would definitely enrich the landscape of our organization. One thing that unfortunately we are not able to do within the ICCBA is to get people jobs at the ICC. This is beyond our reach. We can't do that. Assignment as counsel before the court are exclusively dealt with by the registry of the court. However, being a member of the list is a sine qua non condition to be assigned, and also being a member of the association can really help you create the network that you need to eventually have a chance of being assigned as defense counsel or victims counsel and so on. Now, moving on to the ICC itself. Well, you probably, have heard some about the ICC, so I don't want to take too much of your time with very basic information, but just to give you a little bit of background. Of course, the court was established by the Rome Statute, which was adopted in 1998 and which entered into force in 2002. So the court has already 20 years behind, as in terms of history and practice. The court investigates and tries individuals charged with genocide, war crimes, crimes against humanity, And shortly, hopefully, if it enters into force, will also have competence over the crime of aggression. 123 states have ratified the Rome Statute. And if I'm not mistaken, 19 of these states are from Asia Pacific. But Asia Pacific, quite widely, we're not just counting the Pacific Islands, where, Asia goes from Cyprus to Fiji in this context. So it's quite a large region. The court has 18 permanent judges. They are elected by the Assembly of States Parties. Every 3 years, 6 new judges come into the court, while 6 others leave. There's going to be an election at the next Assembly of States Parties in December for 6 judges to replace 6 departing judges. The court also has 3 principals. Of course, it has the president, who is elected by the plenary of the judges amongst themselves. Our current president is a Polish judge named Peter Hofmanski. His term will come to an end in March next year, and so he will have to be replaced at that point. Our prosecutor, of course, is very well known across the world. Karim Khan has been assigned for, I think, 2 to 3 years now. I'm forgetting the exact time, but he still has quite a long time to go. The mandate is 9 years. So we'll have to wait and see what's in store, what he's preparing for us going further. And then we have a registrar. Our registrar just got elected last February, I think, and came into position in April. His name is Osvaldo Zavala Giler. He is from Ecuador, and he's still very new in this position, but he's a younger and dynamic registrar, which the court much needs. We in defense and victims representatives, we are what we call external teams. This means we are not staff of the court. The court has staff, and if you want to be staff of the court, you can look at the court's vacancy page and apply to any vacancy, and then you're a staff. We at the ICCBA represent external teams, so defense and victims representative, which are not staff of the court. We are very much independent lawyers that come into action upon needed when there's a defendant and when victims need representation outside of the walls of the court. We are assisted internally within the court by two sections that technically are under the realm of the registry, but they're acting independently, which are the Office of Public Counsel for Defense, which Michael is a part of, and the Office of Public Counsel for Victims. You see now some numbers about the practice of the ICC. It's been quite active in the last 20 years, although some people still think that the ICC is not doing enough. But it's doing quite a bit, actually, considering the means and the geographical the extent of geographical zone that it's covering, and all of the conflicts that have been happening in 20 years. Just to give you an idea, right now at the trial stage, so undergoing trial, there's 5 cases. 3 of them are out of the Central African Republic. One of them is the case that I work on. One is stemming out of the situation in Darfur quite some time ago. And finally, one case is out of Mali, and this case is currently being deliberated on by the judges, and we expect that a judgment will be forthcoming maybe late this year, maybe early next year. Now, let's get to the I think the real point of interest for lawyers, practitioners in the Pacific Islands is the admission to the list of counsel. To be admitted on the list of counsel and to have the opportunity to practice before the court, you need to apply to be on the list. And for this, you need 10 years of experience in criminal law and proceedings. I say 10 years because this is what is advertised by the ICC for the possibility to be assigned as lead counsel. But if you have only 8 years, you can still be admitted and have the possibility to be assigned as an associate counsel. So it's not just, this 10 years is not a firm requirement. You must be fluent in English or French because these are the two working languages of the court. And of course, you have to show that you have no criminal conviction, no disciplinary actions have been undertaken against you, and that you have a record of high standing in your practice. At this moment, there's about close to 1,000 counsel on the list. So it's a very, very big list. This being said, among the countries that are represented here today, you are grossly underrepresented in the list. There's only 2 people on the list who claim Fiji as their domestic jurisdiction, while there is 0 practitioner from the Maldives, from the Marshall Islands, or from Nauru. So there's really a need for the Pacific Islands and their Pacific region in general to be more represented on this list, which should be worldwide and representative of the legal communities across the world. Now, if you have a little less experience, but you're still interested in achieving or being assigned in a team at the ICC, there's also a list of assistant to counsel. Our assistant to counsel or legal assistant, as we call them, are incredibly important members of any defense teams or of any legal representative of victims team. They're a bit less in terms of requirements. To be an assistant to counsel, you only need 5 years of experience in criminal law and proceedings and specific competence in international or criminal law and procedure. And also speak English or French. This is because these are the working languages. And so there's also a list for this. I did not check whether there's a lot of Pacific Islanders on this one. I would assume not. I've never really seen any Pacific Islanders around these walls, which is sorely missing. Other positions in defense teams and victims teams can be fulfilled without any admission to lists. For people in early career, there's positions of case managers, evidence reviewers. Of course, there's internships. It can be difficult for people outside of The Hague or of this bubble that we're in to have knowledge of the vacancies in defense teams and in victims representative teams. We don't have the benefit of using the court's website to advertise our vacancies. And so we kind of do it via LinkedIn or Twitter or Facebook or things like that to sort of spread the word that we're looking for people. So by any means, if you are interested in joining a team, please follow ICC practitioners on all of these social media platforms. Then you increase your chances of seeing the vacancies and being able to apply for them. To be admitted to the list, either of counsel or of assistants, there's a procedure, and I encourage you to go see the ICC website, which has a link to a form that needs to be filled, and will give you all of the steps that you need to undertake to submit an application. It can be a little bit time-consuming to gather the material, fill the form, etc. And then, of course, there's a waiting period before a decision is issued. But it's absolutely worth the wait. I think the admission on the list of counsel is a bonus for any lawyer's profile, for its CV, for professional opportunities. And of course, admission then gives you right to full membership of the ICCBA and joining this vibrant legal community. So I really hope that I have enticed some of you to go ahead and apply for the list. As I said, I think Asia Pacific is really underrepresented, and we need to change this together. I'll be happy to answer any questions at the end, but I will now, I think, stop here and leave the floor for other speakers. Thank you so much.
Thank you. Thank you, Ms. Mary-Helen, and for that informative presentation on the introduction to the International Criminal Code. We appreciate your valuable insights and the clarity you brought regarding how to become listed as counsel before the ICC. And it is evident that we encourage more lawyers from the region to come on board with the ICC. And this is a testimony that to ICCBA's consistent promotion of diversity in its representation. And furthermore, as the president just said, we extend an invitation to law societies and bar associations across the region to affiliate with the ICCBA for future collaborations. And if you have missed my name is Rangajiva Vimalasena, and I'm the focal point for Asia Pacific states, as well as the chair of the Professional Standards Advisory Committee of the ICCBA. We are delighted to see today that we have a large number of participants from Fiji and other states such as Maldives, Marshall Islands, Vanuatu, Nauru, and a number of other Asia Pacific states. So if you have just joined in, we welcome you once again. And if you have any questions, please type them in the Zoom chat box or in the YouTube chat so that we can answer them at the end of this session. So our next speaker is Mr. William Wiley Clark. He's the president of the Fiji Law Society. And he's a graduate in law from the Australian National University and University of Sydney. He was admitted to the High Court of the Australian Capital Territory in 1995 and subsequently to the Fiji Bar in 1996. He was a prosecutor with the Director of Public Prosecutions Office in Fiji from 1996 until 1998. And Wiley is a commercial lawyer in Fiji and has been legal advisor of a prominent bank in Fiji for over 17 years. He's a former president of the Fiji Australia Business Council, and he's a member of the Australian Institute of Company Directors, Fiji Advisory Board. And also he's a former president of the Fiji Red Cross National Society, and he's a current member of the governing board of the International Federation of the Red Cross and Red Crescent Movement based in Geneva. And Mr. Clark was appointed to the Law Asia EXCO in 2021, and in 2022, he was co-opted as council member of the Commonwealth Lawyers Association. He's highly regarded legal practitioner who has been involved in advocating rule of law, particularly in Fiji. And today he will talk about promoting the rule of law and ensuring justice, the role of legal practitioners in the Asia Pacific region. Please join me in welcoming Mr. Wiley Clark.
Thank you, Rangajiva, and thank you, Marie-Helene, for that great introduction to the ICCBA and the ICC. It's a pleasure to be with you all tonight, and I'm really, really happy to see the number of participants that have joined us for the session tonight. I promise I will not be 20 minutes because I think the lawyers are more interested in hearing from you there at The Hague about what's more about the ICC and the ICCBA. But I just thought this is an opportunity really just to say a few words about why we in the Fiji Law Society think this is so important, and which is why we didn't hesitate when Rangajiva and Marie-Helene reached out to see whether there was any interest in us holding this webinar. And really, it was quite straightforward for us as a decision, because although the ICC may be on the other side of the world, it's actually relevant to all of us. What the ICC represents: rule of law, access to justice, the protection of humanity, and our fight against impunity. These are all principles which we as lawyers are sworn to uphold. So it's just as relevant in The Hague as it is in the Pacific. And I think it's a mistake to think that the work of the ICC isn't relevant. I mean, I'm a strong believer that it is. And it may be more relevant than we realize for us here in the Pacific. It's often said that we in the Pacific are on the front line of those suffering the impacts of climate change. And that's true. And with that, I think, comes the potential of issues and problems that we need to be aware of, and why being part of the ICC can play such a critical role. As we all know, it's not hard to imagine these things. Climate change will see islands and possibly countries vanish. And that process is going to be extremely painful, a process to play out. An example of that is and we've seen it already here, people are now taking, or countries are now taking precautionary steps to try and mitigate future risk. So as we all know here in Fiji, Kiribati has bought a huge amount, a massive amount of land up in Vanua Levu. The legal implications that climate change pose and the challenges that they pose to us, not only as states, but as lawyers and people, is what's going to happen from all of this. We're still going to be trying to work out what these all are. Are these countries are they going to be sovereign, or are they not? What does sovereignty even mean in that kind of context, in that situation? These are going to be increasingly relevant questions for us. And the reason why it is important and why the work of the ICC is critical is that it's a crime against humanity to forcibly transfer people. That's a crime. And that is something that would, if it were to ever happen, could happen it would have to be tried in The Hague. So it is relevant to us. In addition to that, it's going to be even more practical, not mundane, but things that can easily happen with the freedom of people to move around the world. What is to happen if a person subject to an ICC warrant of arrest arrives in Fiji? We as lawyers are going to have to understand, it'll be very important, I think, that lawyers here understand what Fiji's obligations are and what this person's rights are. How is all that going to be dealt with? So I don't think there could be any mistake that the ICC and what it does is relevant to us. I've also sort of taken note, and I urge all of you to consider that we are very underrepresented within the bar of the ICC, and that's even though Australia, the Cook Islands, Fiji, Marshall Islands, Nauru, New Zealand, and Samoa are all signatories to the Rome Statute. I think we're already a party to this. So I strongly recommend to all of our members and those around the region who form part of our great Pacific and broader community to take the opportunity to join up and be part of this, because it's going to be important, and more so in the future for us, and much sooner than I think we all realize. Thank you.
Thank you, Mr. Clark, for providing us with a very insightful outline of the rule of law and the crucial role of legal practitioners in the region. And when discussing the role of lawyers in international criminal practice, it is crucial not to overlook the significance of their work on the home front as well. As you said, the legal profession plays a vital role in upholding the rule of law, protecting human rights, as you said, environmental justice, and ensuring justice within domestic jurisdictions. So the expertise and dedication of lawyers in their local context contribute to the broader framework of international criminal justice. So thank you once again for emphasizing this essential aspect of the legal profession's role. And true, as you said, Asia Pacific is underrepresented, and the whole purpose of this initiative is to have more and more legal practitioners from the Asia Pacific region to be on the ICC as well as on the ICCBA. So thank you once again. And since we are running out of time, I will quickly move on to our final speaker today. He's Mr. Michael Hurst. He has been a lawyer in the field of international criminal law over 13 years, and is currently a legal officer in the Office of the Public Counsel for the Defense at the ICC. He's essentially an in-house lawyer at the ICC, providing legal advice and support to the external defense teams who represent the accused directly. Prior to the ICC, he worked for the judges of the appeals chamber at the former Yugoslavia Tribunal, the prosecution at the Rwanda Tribunal, and the defense at the Sierra Leone Tribunal and Cambodia Tribunal. Michael is half Indonesian and half German, and grew up mainly in England, where he's called to the bar. He's also the secretary of the ICCBA. He will enlighten us now on jurisdiction of the International Criminal Court today. I will kindly invite Mr. Michael Hurst to speak to us on this very interesting topic.
Thank you, Rangajiva. I will try to enlighten the wonderful group that we have today about ICC's jurisdiction. And it's obviously an important issue because if you want to practice at the ICC, or even if you take an interest at the ICC, it's important to know what the limits are of what the ICC can or cannot do. And Marie-Hélène mentioned earlier that some people complain or are not so happy that sometimes the ICC doesn't do enough. And quite oftentimes, the answer to this is that maybe we don't have the jurisdiction in those cases. And I'll explain more in a second. But the ICC has a very wide and far-reaching mandate. It's designed to try the most serious crimes of concern to the international community, those that affect the well-being of the world. But actually, the jurisdictional limits that the states gave to the ICC is much more limited than what this mandate suggests. And in fact, the ICC's jurisdiction is probably more limited than those of domestic jurisdictions. Take Fiji as an example. Fiji can exercise something called universal jurisdiction over the 4 international core crimes, but the ICC cannot do this. And I'll explain in a moment what the ICC's jurisdiction is, but it's limited by what is contained in the Rome Statute. And Marie-Hélène mentioned the Rome Statute. It's the document that actually gave life to the ICC, and the whole jurisdictional regime is provided for in there. So I'm going to share a screen now with 2 slides on it, because it's helpful to think of the ICC's jurisdiction in 2 different stages. Number 1, what is the actual limit of the ICC's jurisdiction? And just in a moment, I'll cover how that jurisdiction is actually exercised, because the states that designed the ICC separated it into 2 parts, 2 stages. So, as to what the actual limits are of the ICC's jurisdiction, it's helpful to think of 4 questions. If you see crimes potentially happening somewhere, and you think, will that crime be potentially prosecuted at the ICC? The first step is, does the ICC have personal jurisdiction? The ICC can only investigate and prosecute natural persons as opposed to legal persons. So that means only human beings and not corporations and other legal entities. And that human being must be 18 years of age or older. And that's the ICC's personal jurisdiction limitation. The second issue is, does the ICC have subject matter jurisdiction? And Marie-Hélène already mentioned them, but it's those 4 crimes: genocide, war crime, crimes against humanity, or the crime of aggression. The conduct in question has to be one of those 4 crimes, and they are all defined in the Rome Statute in Articles 6, 7, 8, and 8 bis. If it's anything else, for example, piracy or trafficking or corruption, the ICC does not have jurisdiction over those crimes. Also, if you want to know what the actual legal elements of those crimes are, the ICC also has a document called the Elements of Crimes, and that's a good reference document to use to determine what is and what isn't one of these 4 core crimes. And Marianne also mentioned crime of aggression is something that was added later. The actual definition of the crime of aggression was only added in 2010, and the jurisdiction for the crime of aggression was only active from 2017 onwards. The next stage of the sets of questions that you have to ask yourself if you see crimes, alleged crimes, and the question is, can it go to the ICC? Is it happening on the territory of a state party, or is it being conducted, those alleged crimes, by someone with the nationality of a state party? This is the territoriality component or the nationality component. So to take an example, Fiji signed the Rome Statute, I believe, in 1999. So if it happens, the conduct in question on the territory of Fiji, then the ICC would have jurisdiction. But if it doesn't happen on the territory of a state party, then the ICC doesn't have jurisdiction. The situation also exists that the ICC can exercise jurisdiction if the national is a state party member. So if, for example, someone from Fiji commits one of the 4 crimes on a non-state party territory, then the ICC also has jurisdiction. And the last component is the temporal component. it has to happen after 1 July 2002, because that's when the ICC became active. The Rome Statute was signed in 1998, but it was designed to only come into effect once 60 states have signed the Rome Statute. And that only happened in 2002. Now, it depends a little bit about on which territory or which national the alleged crime was committed by, because if it happens on the territory or by a national of the first 60 states parties, the jurisdiction automatically starts from 1 July 2002. But if a state party signs after 1 July 2002, then the ICC can only exercise jurisdiction after that state has ratified the Rome Statute. So, for example, and I believe if, for example, Palestine, it only signed the Rome Statute in 2015, the ICC only has jurisdiction from 2015 onwards on the territory of Palestine. But there's two exceptions that I'm going to go into. The exception to the temporal limitation is that a non-state party territory can issue an Article 12.3 declaration in the statute, and then it can exercise jurisdiction retroactively. So what the state is doing essentially is saying to the ICC, even though I'm not a state party, I want to give the ICC jurisdiction from crimes happening before I signed, but it can't ever go back longer than 1 July 2002 when the ICC became active. The other exception is when the UN Security Council gives the ICC jurisdiction over another situation where we don't normally have jurisdiction. That can also go retroactive to the moment that the UN Security Council gives that referral. Forgive me, it's quite technical, but I'm afraid this is how it is. So just bear with me for just one more moment. There's one other exception to the territoriality component or nationality component. And again, it's the same two things. Even if a crime happens on a non-state party territory, then that state can give the ICC jurisdiction. And this is what happened in the Ukraine situation. Ukraine's not a state party of the ICC, but there are potential crimes happening on that territory. And in 2014, Ukraine issued an Article 12.3 declaration. And therefore, the ICC can exercise jurisdiction on the territory of Ukraine. And the only one other example that we can have where crimes happen on a non-state party territory is, again, if the UN Security Council gives the ICC jurisdiction. And we've had that happen in two situations. One is for Darfur and the other is for Libya. Both those regions or states are not states parties of the ICC, but the UN Security Council, through a resolution, gave the ICC jurisdiction to be able to investigate and prosecute on those territories. So just to wrap that up, what is the actual limit of the territory? What is the actual limit of the jurisdiction of the ICC? It has to be a human being over 18 years of older for us to be able to investigate and prosecute them. It has to be one of those 4 core crimes. It has to happen on the territory of a state party, or the person accused must be a national of that state party. And it has to happen after 1 July 2002, or after that relevant state has signed and ratified the Rome Statute. But there's exceptions to both if there's an Article 12.3 declaration by that non-state party or the UN Security Council has given the ICC jurisdiction. I hope that's clear enough. Now, even though the ICC might theoretically have jurisdiction, if it ticks all those boxes, it doesn't always mean that the ICC can step in and actually exercise that jurisdiction. The states made a distinction for that. Now move on to the next slide. There's 3 trigger mechanisms. We call them trigger mechanisms. Even if a potential crime ticks all the jurisdictional boxes, for those crimes to actually physically and tangibly be in the courtroom at the ICC, one of these 3 things must happen. Number 1 is a state party can refer a situation. And the majority of cases that have landed at the ICC have been through this trigger mechanism. Usually a state party says to the ICC, I want you to investigate something happening on my territory or by one of my nationals. Usually it's territory. And for the vast majority of situations, that is how a case lands at the ICC. Recently, we've had 2 situations where one state party refers a situation in a different country's territory. And that was in Venezuela and also Ukraine. In Venezuela, there were 7 states that told the ICC, we want you to we want to refer the situation to you, and now the ICC is conducting, I think, preliminary examination or investigation in Venezuela. The Ukraine situation, Ukraine gave a declaration under Article 12.3, so the ICC technically has jurisdiction, but it still took 43 states to make a referral so that the prosecutor can open an investigation. That's the first scenario. The second scenario is if the UN Security Council refers a situation. And again, I've already mentioned it's Libya and Darfur, the two examples where the UN Security Council did that, and it also has the effect of giving the ICC jurisdiction over territories and nationals that it normally wouldn't have jurisdiction over. And the last trigger mechanism is that the prosecutor can, if he sees potential crimes happening, open an investigation himself. But if he wants to do that, he has to get permission from the pretrial chamber. It's a safeguard designed so that the prosecutor can't just open any investigation that he wants. He has to be able to demonstrate to the pretrial chamber that there is enough evidence to show that those crimes are potentially happening. So to get potential crimes to the ICC, one of those three things must have happened. And the last example we have, Kenya was one of those examples of the prosecutor beginning an investigation himself. I'll just mention two final points, which is the crime of aggression has a special jurisdictional regime. If it's genocide, war crimes, or crimes against humanity, the jurisdictional question is quite simple. It's the way that I just described to you now. But the crime of aggression, which is a newer crime, which took a bit longer to define, and that is governed by Article 15 bis and Article 15 ter. I won't go into the very specifics of it now because it's a bit more complex, but states had to ratify that specific amendment so that the ICC has jurisdiction over the crime of aggression on their territory or by their nationals. And the simplest way to put it is that both, and crime of aggression, just to remind people, it's when one state attacks through armed force another state when there's no legal basis to do so under the UN Charter. The easiest way to explain it is both the aggressor state and the victim state need to have signed the amendments to the Rome Statute that activated the crime of aggression. And there's only 45 states so far that have signed it. And it's one of the reasons why, for example, the ICC doesn't have jurisdiction over the crime of aggression in Ukraine, even though a lot of people are saying that that's a potential crime that is happening there, because neither Russia nor Ukraine have signed the amendment. In fact, neither of them are even state parties. The very final point is that jurisdiction is different from the issue of admissibility. Jurisdiction is what I've just described, what powers the ICC has over persons, crimes, territory, and nationals, and if it happens in the right time. Assuming everything is still ticked, assuming jurisdiction exists, maybe the ICC still won't actually conduct investigations if the situation isn't admissible. And this is governed by Article 17 of the Rome Statute. And situations where the ICC wouldn't find a case admissible is, for example, if the domestic state is prosecuting or investigating that crime themselves. Then the ICC will say, we won't take over, we won't actually investigate these crimes because another competent authority is investigating it, the domestic authorities. And that's a question of admissibility. I hope that clarifies a little bit. I'll stop sharing. I appreciate it's a little bit technical. And a lot of commentators said it would be easier if the states had designed the ICC to have just universal jurisdiction. For example, states that have universal jurisdiction, like Fiji, if a crime against humanity is happening anywhere in the world, they consider it, because it affects everyone, that state can exercise jurisdiction. But that's not exactly how the states designed the ICC. It designed it with quite strict jurisdictional limits. And I hope to have explained them in the last few moments, and I'm happy to answer any questions about it.
Thank you, Michael. Thank you for shedding light on the important work carried out by the ICC and its jurisdiction. I'm sure it has given us a lot of understanding of the role of the International Criminal Court. And thank you once again for that very enlightening presentation. So since we are slowly coming towards the end of the webinar. I will now open the floor for a brief question and answer session. And if you have any questions, please feel free to send them via the Zoom chat or the YouTube chat, as the webinar is being broadcast on both platforms. And as I said in the beginning, we will do our best to address as many questions as possible within the allocated time. And the first question that I would like to forward to the panel is from Nick Barnes from Fiji. And he's asking, how are defense teams allocated and how are they paid? I think perhaps Miss Mari, Helen, or Michael can answer that question.
Yeah, I'd be happy to answer that question, and thank you. It's an important question. It's true. I didn't talk about that at all in my presentation. So at the very beginning, when a suspect is transferred to the ICC, this suspect is well at the detention center here in The Hague, and this person meets from a representative of the registry and is presented with the list of ICC counsel. They will probably ask the person what kind of lawyer they're looking for in terms of experience, background, etc. And so the registry will present a selection of counsel who fit their criteria. The suspect will then be able to choose to interview, if they want, several lawyers, and to choose one of them. That's how the lead counsel is chosen. And then lead counsel gets the power of attorney, is officially assigned by the court. Once that is done, lead counsel can choose his or her team members. They'll have the opportunity to hire whomever they want to join the team. The team will start very slowly. At the beginning, at the pre-trial stage, the team is rather small. Once charges are confirmed and the case is headed to trial, the team then gets a bit more resources to go through the trial. The payment, that's a very interesting question. When a suspect is handed to the ICC, there's going to be what we called a indigency investigation about this person. The registry will ask the person questions about their financial situation, will investigate the financial means of the person, and will determine whether the person is or not indigent. If the person has sufficient means, then this person will be expected to pay the cost of their defense team. Also, sometimes that it happened in the Ruto case, for example, out of Kenya. In this case, the Kenyan state accepted to pay for the defense. So these lawyers, these teams, were paid by the Kenyan government. That's quite a rare situation, however. Most of the time, suspects will be declared indigent. The reason being that to sustain a full defense team for several years, that the length of the proceedings is quite long here. So for several years, very few people have the means to pay that much money from their own pocket. And that is why the ICC has put together a legal aid system. So most of us here, actually all of us at the moment, all current detainees are indigent. And so we're all being paid from the legal aid system. The legal aid system was adopted, well, the current one was adopted in 2013. It's not a very generous legal aid scheme, we have to say, and it's also quite outdated. And that's why for the last few years, there's been negotiations to try and reform the legal aid system. The ICCBA is very much involved in these negotiations, trying to get better conditions for the council, but also for support staff who at the moment don't benefit from any labor rights. That's one of our most, I say, involved campaign right now, trying to get this reform passed. But yes, basically, I hope this answers the question. Most of them are legal aid cases. So I'll finish here.
Thank you, Mari Helen. And also, there's another question from Waitea, I think from Fiji. And the question is, have there already been communications sent to the court concerning a case of forced displacement relating to climate change? And is the ICCBA working group on ecocide working on that particular matter as well? Perhaps Michael can
yes, I'm happy
answer that question.
Happy to try to answer this question. I'm not entirely sure if there's been communication sent to the court on this issue, because a lot of communications are sent to the court. We don't necessarily always see them because some of them remain confidential until the prosecution issues some sort of statement or letter to the entity that sent the communication, giving them an answer. So I'm not aware of any. I'm not saying that that means none have been sent. The issue is, ecocide is not one of the 4 crimes that the ICC has at the moment jurisdiction over. It's neither genocide, nor war crimes, nor crimes against humanity, nor crime of aggression. There are people and groups who are trying to promote the idea that ecocide should be one of the crimes that the ICC has jurisdiction over yet, but it hasn't happened yet, to make it a 5th crime. If and when that does happen, the ICC would only have jurisdiction over that crime 1 year after it's accepted by the Assembly of States parties, and only in relation to the states that have ratified that agreement, that amendment. So the limitation for ecocide, if and when that does become a crime, would still be limited until more and more states signed up. There's a threshold by which I think if either 2/3 or 7/8 of the member states parties have accepted the amendment, then it applies to everyone that is signed up to the ICC. But that hasn't happened yet, I emphasize. The ICCBA is looking at this issue, still more at, I think, the abstract level of whether or not it's a good idea to have ecocide as a crime, and we value people coming and emailing the ICCBA about your suggestions and what your thoughts are, because then we can feed it into the debate that we can then present to the ICC and say whether it should be a crime or not. So we are working on it at that level. We don't work on specific situations. That's more a matter for individual groups or states or victims groups who may want to send a communication to the prosecution. And in fact, everyone in the webinar right now has the power under Article 15 of the Rome Statutes to send a communication if you have evidence of potential crimes, to send it to the prosecution under Article 15. And I invite you to look at the ICC website for that. But then, yeah, bear in mind that ecocide isn't a crime at the ICC yet. But nevertheless, there are other ways to potentially investigate conduct that appears like ecocide and forced displacement. I'm glad that the asker mentioned forced displacement. That is both a war crime and a crime against humanity, no matter what the actual motivation is for the forced displacement. So perhaps it can be qualified as a war crime or crime against humanity, and invite, again, people to look at the elements of crimes to see whether the conduct satisfies those elements. I hope that answers the question. I don't know if Marie-Hélène or William wants to add to that.
Yes. Do you wish to add anything, Mr. Clark or Ms. Marie-Hélène?
Just very quickly about the question of whether the working group is tasked with that. No, not at the moment. The working group really is in the very beginning of its work. So they're mostly looking into whether it is appropriate for the ICCBA to take a position on this crime and on whether this crime should be recognized before the court. But as I said, it was only established a month ago, so it's still early days, and definitely if there is a report at some point, we'll consider making it public so that people can know what the position of the working group is at a later stage. Thank you.
Thank you. And do you wish to say anything, Mr. Clark, in response to that question, or can I move on to the next question?
No, please. Yeah, no, go ahead and move on.
Okay, thank you. And there's another question from Samanunu Waningi from Fiji. The question is, if a Fiji lawyer is on the list of assistant counsel, how do we assist and do the work? Is it online via email and Zoom meetings? Just wondering how we assist practically from Fiji. I think I will forward that question to Mary Ellen.
Yes, thank you. Most assistant to counsel live here in The Hague. They move here to take their positions. Most of them, not all of them. There is actually quite a few who offer remote assistance. It is not impossible to assist from Fiji. I know in my team, we have a member who lives in Singapore and another one who lives in Texas. And they're very much, members of our team. A caveat to that is that at some point in their career, they were here in The Hague, and that's how we got, to know them. But yeah, no, most of the time, a council will appreciate that the team members come and live here in The Hague. And that's, for very practical reasons, especially in defense where we have a client in detention, it's important to have people here to visit the client, to bring him things in detention, to take care of his well-being. It's also important to attend hearings, to be here, and especially in the trial phase where hearings are continuous. So, but as I said, not impossible. If you're getting a call from a council in The Hague and they want to hire you, but you're not quite ready to move here, by all means, try and negotiate remote assistance because it's being done here regularly.
Yeah, thank you, Mariela. And I think we can give another 1 or 2 minutes. If you have any questions, you can type them in the chat box. And also, it's very promising to see that we have participants from Afghanistan, Australia, New Zealand, Maldives, Sri Lanka, Japan, Palau, India, Pakistan, Nauru, Yemen, China, Bangladesh, Tonga, and Bulgaria, Chile, Algeria, France, even Egypt. So it's very encouraging to see the participants from all over the world, not only from the Asia Pacific region. So we have one more question. It's from Mohammed Awad, I think from Egypt. He's asking, do not you think that the definition of the 4 crimes of the ICC are quite similar? I mean, that maybe a crime happened and can be defined under any title of the crimes. It says, don't you think that the definition of the 4 crimes of the ICC are quite similar? Michael, do you want to say anything in response to that?
I can start it off. Some of them are similar. They have similarities. And in fact, quite often you see cases whereby the same conduct is charged both as a war crime and as a crime against humanity. There are still differences because they have different, what we call chapeau elements. So for example, if for it to be a crime against humanity, it has to happen in the context of a widespread and systematic attack. For it to count as a war crime, it depends if it's in the context of an armed conflict or not, but there's different war crimes that apply depending on if there is an armed conflict that is international or non-international. So there are different elements. The other 2 are a little bit more different, I would say. Genocide and crime of aggression is particularly quite different. Genocide, the big idea is that when a perpetrator wants to destroy in whole or in part a whole group based on a certain protected characteristic like nationality or ethnicity or religion. So it's still a little bit different. Although, yes, sometimes the conduct can still be described by genocide as well as the other 2 crimes. Crime of aggression is quite different because it refers to an armed force from one country attacking the territorial integrity of another country without justification under the UN charters to do so. And we call that and it's usually the leaders that are responsible, those who are in charge of the armed force. And it's a leadership crime. And you can be prosecuted if you wage, initiate, or plan that act of aggression. And each one has slightly different historical and legal reasons for why they're in the ICC statute. But yes, some of them are quite similar, but at the same time, if you look at the elements closely, there are still differences in each one.
Okay, thank you, Michael. I think that provides sufficient clarity to that issue raised by this participant. And I think that's all time we have got today for this webinar. And so we come to the end of this ICCBA webinar, and I would like to extend my heartfelt gratitude to our esteemed partners, Fiji Law Society and the Fiji Women Lawyers Association for their collaboration in making this event possible. And especially I want to thank Dominic from ICCBA, the Executive Director, as well as Mele Rakai, including everybody else from Fiji, for their support and dedication. And your support and commitment to advancing legal practice and promoting access to justice in the Asia Pacific region are truly commendable. And I would also like to express my sincere appreciation to all participants who joined us today. Your active engagement and insightful questions have enriched our discussions and underscored the importance of fostering dialogue and knowledge sharing in the legal community. We hope that this webinar has provided you with valuable insights into the International Criminal Court, the process of becoming a listed counsel, and the impactful work carried out by the ICCBA to encourage legal practitioners from underrepresented state parties and non-member states in the Asia Pacific region. Please stay connected with us for future webinars and events as we continue our efforts to strengthen legal practice, promote diversity, and uphold the principles of justice. Thank you once again to the FLS, FWLA, and all participants from all over the world for being a part of this meaningful webinar. Wishing you all continued success in your legal endeavors. And thank you and have a wonderful rest of the day. Mode Vinaka.